A very warm welcome to everyone, and thank you for joining us for this post-judgment webinar. I'm Priyanka Naidu from the Legal Resources Center, and I'm joined by some of the members of our Wild Coast applicant communities who have taken Shell and the minister to court and have won. The webinar will be a discussion on the judgment that was handed down by the Makhanda High Court yesterday, and our panelists will be sharing their reflections and feelings. We encourage you all to post questions in the chat, which will then be answered in a Q&A session. And as a quick refresher, you would remember that this case was brought on an urgent basis back in December 2021, when the communities along the Wild Coast approached the Makhanda High Court to interdict or stop Shell from carrying out a seismic survey along the Wild Coast. This was essentially done until a court was able to determine Part B, which was the merits of the case, whether Shell had actually undertaken their legal obligation to meaningfully consult these communities. I will now hand over to Vulmeen Vikram, who will provide us with a crisp summary of the judgment.
Thank you, Priyanka, and good afternoon to everyone. Very happy to have so many people joining us. I'm going to try and give a very quick summary of the judgment. And I think the most important thing to understand is that this case was about whether the minister, when he decided to award the permit, both the original one in 2014 for exploration and the renewal, whether that decision was lawful. Right, so whether it was a good decision. And in our law, there are a number of reasons why a court will decide that a decision was not good in law. It's not about whether it was the right decision, it was whether it was a lawful decision. So, for example, if the application itself was unlawful, then the decision to grant it would be unlawful. Or if there's evidence that the minister did not apply his mind, or he took the wrong things into consideration, or he didn't consider relevant things. So those are all reasons in our law where a court can decide that this was a bad decision. So in this case, the applicants had a number of reasons why they said this decision was bad. And the first and probably most powerful one in this case, and the court said that on this basis alone, the decision was bad, was the fact that Shell and Impact Africa, in their application, while they consulted many people, they completely ignored the communities who would be most directly affected by this exploration. That's the communities who live on the Wild Coast, who survive off the ocean. It's central to their livelihood. They fish. It is also central to their cultural and spiritual life. These communities had no idea that this permit had been awarded or renewed. They heard, as the rest of the public did in about November 2021, that this was even happening. Now, a critical part of this argument was that Shell said that they did consult these communities because they consulted 3 monarchs in the former Transkei, and that is the same as actually consulting all these communities. Now, this was a critical issue because it is a consistent complaint by poor rural Black communities in the former homelands who remain invisible to the state and to developers, who ignore them and say, it is enough for us to consult with your traditional leader because that's the same as consulting with you. That was the argument raised again here, and the court definitively stated that is an approach that is a relic of a colonial past, has no place in the constitutional order. The community is not the same as the chief or the king or any traditional leader. The community consists of individual members who are individually, potentially directly impacted by a decision and must be consulted as such. And of course, Shell went to the trouble of consulting other people like commercial fishers, recreational fishers, industry, individually, but ignored this community entirely. And on that basis alone, the court said this decision, the application itself was bad and should never have been awarded. the court also made important statements about what meaningful consultation means, and that it's not just a tick the box, but that you must actually aim to reach some sort of consensus, and that was clearly not done. So that was the first and kind of critical element of the challenge. But then very importantly, the court said, because of the interest of this case, they don't have to find other reasons why the decision was bad in law, but they will point them out because for various reasons, the minister's decision is unlawful. And so they made very important points here. The first is the court said, clearly on the evidence before us, there is huge contestation over whether this seismic survey will cause harm, whether that harm will be serious and whether it will be irreparable. And in the face of such contestation, the minister surely should, one, have applied his mind to independent evidence of the impact of this survey, and not just what Shell had put before it. And secondly, should have applied the precautionary principle, because this is about the environment. And if we're uncertain, then we should handle it with caution. That's the first. Secondly, the court said the spiritual and cultural rights of the directly affected communities and the impact, the potential impact on those rights is relevant to this decision. And there's no evidence that the minister even considered it. And for that reason also, ignoring relevant evidence means the decision is bad. And I think it's important to, some people think that sounds quite out there. But as our counsel said in one of the hearings, we live in a Christian country where mining under a church or a cemetery would be an outrage and would certainly not take place without detailed thinking about the impact that has on the spiritual rights of many South Africans. In this case, that was just completely ignored, as if it's not the same when the spiritual rights are those of indigenous people. And it's difficult to understand for Shell. Well, that's their problem. Then the court also said that the minister was duty-bound to consider the impact of climate change and the integrated impact on the ocean. So I'm not going to say much about that because my colleague Melissa, I think, will, but those were equally important decisions by the court that in future, those considerations must be taken into account. Finally, I just want to mention two things that were, I think, important in this case. The first is that the court said, there were lots of statements made by the minister, by Shell, that this project will bring enormous economic development, an influx of wealth and jobs into the Eastern Cape, into the country, and that kind of outweighs any other considerations. Well, the court didn't necessarily have to make a finding about that, but it did say that for all these sweeping statements, the the respondents were not able to put any concrete evidence before the court that that is actually true, and that we are actually dealing here with potential development that will be great locally and nationally. And I mean, they certainly had the time to do that, and they couldn't, which was critical. And finally, something that probably made the applicants smile a little bit is that one of Shell's arguments was that the applicants were not entitled to approach the court at all because they did not exhaust their internal remedies. So in terms of the legislation, it is in fact required to first do an internal appeal before approaching the High Court. Now, the applicant said, well, for several reasons that would not have been feasible. First, they heard about it so late, but secondly, also, Minister Mantashe made it very clear what he thought about the case and about the applicants by publicly calling them agents of apartheid and colonialism of a special kind. And the applicant said, I mean, in those circumstances, we cannot be expected to approach a minister like that for an appeal. Now, the court decided, really made clear their thoughts on that very point, and said that indeed the bias of the minister was clear, and so only in exceptional circumstances that you don't have to do an internal appeal. And they thought the circumstances here were actually truly exceptional. So that was certainly one way in which the minister shot himself in the foot really badly. I'm going to leave it there and hand back to you, Priyanka. Thanks.
Thank you, Vilmin. That was an excellent summary of the judgment. Nontle and Sinagugu, who are in transit, I'm wondering if you would be able to come onto camera, and I will hand over to you, Nontle. You've previously said that this case was not just about Shell, that it's also about making sure that the voices of rural communities are as important as the voices of the elite, and about ensuring that the pursuit of profit does not override the protection of human rights. Could you please share where you were when you heard the news that the communities had won, and how this was received by your community? Over to you, Nontle. You are on mute. Kindly unmute.
Mute. Oh, thank you. I forget that. Yeah, thank you so much for this opportunity. Yeah, yesterday when we received the news, first of all, we were really worried, scared. And what worries us, it was not that we don't trust us. We don't trust ourselves. We don't trust our legal team. We don't trust everybody that is putting their hands on this matter. What worries us, it was the economy of South Africa, because it's very, very weak. And we were worried that the weak economy can influence the judge decision. That was the most worries us on this case. And we were really, really cold. And yesterday, we were even been called to go to Gqeberha, and we said, no, we're not going to go to Gqeberha, but we go to gather together and to receive the news together, even if the news it's bad or it's good, but we need to receive the news together. And where we're going to take a step, where we're going from here if the news are bad. And also, it was not just only to receive the news, and also to pray together. That's what our stance took yesterday. That is why also we decided to make sure that we are at Komkhulu, at Xolobeni. But when we received the news, it was the best news that we ever had in our life, because this case, it was not just only for the ocean, but it was about the planet that it holds all of us. Now we know that if this case, as we heard, that it's been in favor of us, we know that it's not only us that we won, but we won also for the planet. That is why it was the most important case. And we see that the judges also, they did consider the climate crisis. It was the most a big victory. We were jumping up and down outside. Even yesterday, it was too windy, but we were sitting outside because we're too many. Our hall was too small, but we decided to sit outside. We jump on that wind. The elders as well, they were really, really pleased about the court judgment, because they said that this is a repetition of the time of Jesus Christ, where Noah in the Bible says that let's build the ship where it's going to host everybody before the end of the world. But there were some people that they were disagree. They said that you are just bringing theories. There's nothing Noah that can happen. But those they believed in Noah's theories, they just being safe. They said it's the same situation, because today people are still not believing that we are in crisis. the ecological crisis is real. And if we are in there's ecological crisis, it means that everything goes wrong, because as human beings, we're dependent from the nature in order to survive. But if the nature, there's nothing good, that means there's nothing good also to the human being. That is why the court ruling yesterday, it makes everybody happy yesterday, but they keep saying that this is the beginning. There's still a long way. We still need to be ready. We still need to go around and educate our people about the planet, about the climate crisis. Because if we are not doing that, that means this crisis economy that we are facing will be pushed in a way that people are going to be desperate and agreed.
Sorry, Nontle, I think you've been muted again.
Thank you.
Thank you for that, Nontle. Indeed, this was a huge victory for both people and the planet. I am going to move over to Jomo Sorry about that. Thank you, Nontle. That was indeed a huge victory for the people and the planet. I'm going to move over to Jomo Kuselo. Jomo, thank you so much for joining us from Makhanda. We know that you had to make a very long journey to get to the court yesterday. Could you please share with us how you felt once you heard that the communities had won, and how important this is for the Dwesatwebe community?
Morning, everyone. In my side, on Wednesday first, I can't sleep because I'm scared and I have stress about the judgment. But yesterday, I'm very, very excited and happiness because the judge, it's our side. On Wednesday, I'm worried about it. I'm not trusting with a team working together. I will trust, but the problem is that ministers have a lot of money and share a lot of money. Then maybe we do something for the block that the judgment we are against us. But now I'm very happy and I don't have words because I'm very happy and excited, because if you check that judgment, it's speaking about our ancestors and speaking about the whole communities. And that judgment, we are not covered only Dwesatwebe or Eastern Cape only. It's covered the whole world in South Africa. When I'm looking and I don't have experience about that document of the lawyers or judges. Also, the Dwesatwebe, it is too much happy. Even yesterday, I can't sleep. I have called left, right, center from different places like Cape Town and Eastern Cape, Gauteng province, asking about that judgment. Also, Priyanka, I'm happy and I'm sure the community is very, very happy. And if we are not fighting, gentlemen, we are standing. The ministers doing everything about the coastal or the beaches. If you see something, you must do something and then can stop everything. Okay, thanks.
Thank you, Jomo. One of our other panelists is currently in transit, so we will come back to him when he is able to join. Sinagugu, I'm going to go to you. You deposed to the founding affidavit and explained how over generations your community have conserved the land and sea, but the land and sea have also conserved you. In the judgment, the court recognized the intimate relationship that the Wild Coast communities have with their seas. Could you just take us through your thoughts on the importance of this, and this especially being recognized and emphasized in the judgment, seeing as Shell argued that it was not necessary to take this into consideration? Over to you, Sinagugu.
Thank you very much, Priyanka. Yes, the judgment is okay, supposed to be on video. Okay. Thank you very much for the kind intro. I must say that the judgment is indeed groundbreaking in the sense that this is one of the few judgments where the judges really listened to what we were saying. All what we were trying to say in many affidavits that the legal team kindly collected from us all over the entire coastline, where we were trying to explain. I recall, for instance, in some instances during these court hearings, even in the interdict, where I think it was in the December interdict, when the Shell advocate referred to unprecedented indigenous rights and the religious practices that concern the ocean. So and that was very annoying, because calling our rights and our beliefs as being unprecedented, why should they be presented to him when he's not part of our culture? Because there was nothing that we put forward which was not true. That's why most of the things we said, whether you were looking from Bonderland, you were looking from Port St. John's, looking Amadiba in Port St. John's, in Dwesa to the Kaimouth, there was consistency in terms of the belief system. The academics who work with these in the indigenous people along the Wild Coast, they were also in agreement with what we're saying. And these are the things that have been documented. But to really have somebody representing Shell, a multinational corporation, to and then to come and question our belief system, of course, that's how maybe the courts work. But I'm just going to read, for instance, paragraph 115, where it says the applicant communities contend that they bear duties and obligations relating to the ocean, to the sea, and other common resources like our land and the forest. It is incumbent on them to protect the natural resources, including the ocean, for present and the future generations, close quote. And I think to have the judges being able to listen to what we were saying, which is something that is coming from the indigenous perspective, the indigenous knowledge systems, and be able to consider that when they are giving judgment. That was really for us very critical to say, to recognize in terms of our religious rights, our livelihood rights, and our climate change concerns, because we went to the very fine details of how climate change is actually, and they were able to pick up those little things that really matter to us and to be able to say this. So it is in that score that I say this judgment was really groundbreaking, and it is setting a very good precedent, not just for us, but for the future generation and for the future and the health of this planet. I thank you.
Thank you, Sinagugu. Indeed, it is a groundbreaking judgment. I'm going to move to Melissa next. Melissa, could you please come on camera, and could you take us through your thoughts on the judgment, especially related to the fact that the court held that the minister also needed to independently take into account climate change when making decisions such as the awarding of exploration rights. Could you give us your thoughts on that?
Thanks, Priyanka, and then very warm hello to everybody that's on this call. I see we have quite a few people attending the webinar, so it's really good to have you with us. So the intervening applicants were Natural Justice and Greenpeace Africa, and you might recall that they were part of an initial application to interdict Shell from starting the seismic surveys on the 30th of November. We were unfortunately unsuccessful in that case, but nevertheless the community's case was taken forward and they were successful in that interdict application. So when it came to the review in the second part of the application, it stood to reason that we would join together and become part of the same application. The intervening applicants aligned themselves with the positions of the main applicants, or the applicants in the main application. And there were a couple of points that we wanted to add for the consideration of the judge. The first one was in relation to climate change and the fact that climate change was not considered in any of this decision-making process. And the second one is around the requirements of the Integrated Coastal Management Act. So let me start with the climate change position. And I'm sure that most of you that are listening to this webinar will know and understand climate change and the severe impact that it is having and will have in the future on our ocean resources, and that this is largely attributed to the oil and gas sector and the emissions coming from that sector. So any oil and gas exploitation we view as undesirable, unnecessary, and we must keep oil and gas in the ground and under the ocean where it belongs. So essentially, the issue was that climate change considerations were never taken into account in any of the assessment processes for the exploration right and in the environmental management program. We said that because climate change wasn't considered and South Africa's obligations in relation to climate change to keep us on a path of a 1.5 degree temperature increase, none of this was taken into account, none of this was assessed. And we had expert evidence from Professor Mark New, which also told us how most of the discovered reserves of oil and gas cannot be burnt if we are to stay on the pathway to keep the global average temperature below 1.5 degrees. And this was essentially accepted by the court, and finding that authorizing new oil and gas exploitation with its goal of finding exploitable oil and gas reserves will have the ultimate result of production, and this is not consistent with our international climate change considerations. And we view this as a very serious issue, even at the exploration stage. So meaning even if it's in relation to seismic surveys or exploratory well drilling, because part of the process is simply exactly that. It's one part of the process, which is with its ultimate goal of getting to exploit these oil and gas reserves. So the court agreed, in fact, and relied on some previous judgment and found that the processes are discrete stages in a single process that culminates in the production of oil and gas, production and combustion of oil and gas, and the emission of greenhouse gases will exacerbate the climate crisis and impact communities' livelihoods and access to food. Essentially, the court decided that it didn't come to a conclusion on the science of it or anything like that, but said that had it been considered by the decision maker like it should have been, they may well have decided that this exploration is neither needed or desirable. And this is very important, for the need and desirability arguments that are being made around oil and gas exploration, oil and gas, any work associated with oil and gas and its need and desirability in our current climate context. So we are very, very elated with what was included in the judgment in relation to climate change. It sets an excellent precedent for other cases going forward. The second point that I referred to is the importance of the Integrated Coastal Management Act. Now, the Integrated Coastal Management Act requires that any functionary or any organ of state that is charged with overseeing management of the ocean in some way. So in this case, granting of exploration and production rights is required to take into account a number of aspects of the Coastal Management Act. And this doesn't only apply where an EIA is being conducted. So that was an important principle that was agreed by the court in this case. And fundamentally, the Integrated Coastal Management Act requires the consideration of more than just human impacts and more than non-human species, effectively, so animal species in the ocean, but in fact the whole community and the interests of the whole community of the ocean. And so this is essentially how these human and non-human species interact and rely on each other. So the fact that none of this was considered was quite a clear point and a really good finding in that review ground, that it just wasn't taken into account. It was required to be taken into account, and on that basis, that review ground was successful. So I'll leave it there, and perhaps if there's any further explanation needed, we can come to it in the Q&A. Thanks, Priyanka.
Thank you so much, Melissa. We're going to move into the Q&A session now. There are a few questions in the chat, but I would like to encourage everyone to also keep the questions coming, and we will note them and ask them to the panelists as they arise. Nontle, first question goes to you. The Shell judgment quoted a previous judgment of the Constitutional Court in Fuel Retailers, which held that the development that is envisaged by the Constitution is people-centered and sustainable development. Could you please share your thoughts on this, especially since the Tolobeni community have fought so resiliently and continue to fight for bottom-up development? Over to you, Nontle.
Sorry. Do you hear me now?
You are audible.
Okay. Yeah, this is very true. Development must always take a caution when it comes to environment, because most of the time we always put a development first, and we put environment after. That is the biggest problem that we always have when it comes to development, because most of the time when there is degradation, or when there is development, when there is too much destroy in the environment, there are environment, or there are nature that you cannot rehabilitate. But we always says that, no, let's put a development, which is the problematic in future. That is why right now we crying that if Shell case was being prioritized, it means that we are part and parcel of promoting the fossil fuel, which is more bringing the negative impact to our climate crisis. That is why we said that right now, let's prioritize the environment before the profit. And the judges, what they've done, they prove us correct, and they prove Shell wrong this time around, which is the first history where the judges also, they prove the communities correct, because most of the time we've been called that we are anti-development, when we said that development and environment must be put together equally, not the other way around. Those are the cry of communities that we always say that, please, let's consider environment. And the problem, the biggest one, is that when we talk about environment, we always excluding the human being. That is the problem of the knowledge that is there with the people. And in order to change those mindsets, we need to put more educating to our developers as well, to our government official as well, because that information, that education, it needs to go to their own heads, because people on the ground, they are very aware about environment. Thank you.
Thank you, Nontle. The next question is from Gary. Gary has asked if someone can comment on the JP's finding that consultation needs to be a bona fide two-way process aimed at achieving consensus on all future EIA processes. I'm wondering if Johan would like to take that question. Okay, I think that I will then hand the question over to Vilmin. Could you please answer that for us? Thanks.
Sure, I'll make a start. So, yes, I mean, that is a very important statement. And I think what's important to consider here, because I also see, you know, in some of the questions people refer to pre-prior informed consent. So we always talk about the difference between consent and consultation. And in this case, you know, it was not about land rights. So the communities were not claiming the right to free, prior, informed consent. They didn't need to, but so they didn't. They certainly did claim the right to meaningful consultation, which I think we can it's useful to think about as free, prior, informed consultation. And that means, you know, to realize that principle that the judge president referred to, it means that you really need to create some equality between the parties consulting. It means that you need to empower the community that you may be consulting with enough information about both the negative and positive impacts that may follow. That information must be provided before any consultation starts, and the community must be empowered to understand what it means, get advice on it, independent advice, and, you know, be able to debate it and engage on their opinions for as long as it takes them. And then, of course, their consultation must be free from any kind of pressure or coercion. Now, we sometimes think about that as, you know, someone pressurizing the community, and it could be the minister, it could be the mining company. We often see that. But I think we must accept that it's also the pressure on communities in the context of our economic crisis, and in particular in the context of how the extent to which rural development has failed. I mean, you know, the communities in this case, if you look at Stats South Africa, they're probably considered statistically some of the poorest in the country, right? So it's people for whom development has not arrived. And so that is part of what makes people not free, right? That is part of what, in the absence of alternative options, if your only option, and certainly the state is presenting this as the only option for you to ever get development, is if you say yes to this. And that in itself, I think we must really push back against, because that undermines the principle of free, prior, informed consultation and of, you know, the meaningful consultation that we're talking about here. If you're only putting one option on the table, then that's not an option. And in the face of that kind of pressure, it is extraordinary that these communities say, well, we don't want this. And we actually have our own understanding of the development that we do want. And it's almost ironic that, you know, people who say, these communities they're a front for environmentalists, whatever, they don't have their own views on this. You know, I mean, I can almost see why people would think that, because there is no alternative. This is the only option that is being presented to them. And yet their own resilience and agency has allowed them to say, well, no, we have our own vision for a bottom-up kind of development, and that's what we want. And, you know, if we can't rely on the state to provide alternatives, then we'll make them ourselves. And that is what it takes to really talk about meaningful consultation. Sorry, there was a long answer, but it's Johan's fault because he didn't respond.
Thanks, Philmin. That was a great segue into the next question, which is from Lemise, who has said that some top officials from the Department of Mineral Resources and Energy have suggested that communities are being canvassed to go to court and block seismic surveys and essentially development. How do the applicant communities feel about such assertions? Also, do communities believe that there is a national consensus on what sustainable development is? And if not, what can be done to address that? Sinagugu, can I give this question to you? It is a lot, so if you would like to share it with someone else, let me know, but over to you.
Okay, thank you very much, Priyanka. Priyanka, this statement is symptomatic. It's a symptom of politicians not wanting to listen to the coastal communities, to indigenous people, to in particular to the previously disadvantaged people. They say this thing because they don't want to hear. I often say, when we vote, politicians always behave like when we vote, we also give them our minds, our ability to reason away. If this is what they believe, then they should have come. This is a good enough reason for them to come to coastal communities to listen to what they are saying. If you were to look back on the 5th of December, when the Amatiba Crisis Committee sent out a call for the entire coastline of South Africa to go out to protest, you're looking at the response. The response by fishermen. And if you're looking at all the coastal communities, all the villages along the Wild Coast, they are questioning the government who had given them the permit to fish and then turn around down the line and now wants the ocean to be used for oil and gas exploration. Coastal communities are concerned about their livelihoods. The ocean, no one, including Shell and government, has done any preliminary study or a survey to establish the value of the ocean in terms of livelihoods. How many people, how much per month, per year are the people getting from the ocean? So this statement, which the politician, in particular the Minister for Mineral Resources, has been saying, and it is very sad that these things are being said about coastal communities. When you look on the flip side, you have a democratically elected government who has decided to go to court and partner with a multinational corporation instead of listening to what the people are saying. Who is the sellout there? Who is pushing colonialism there? Who wants to sell the ocean, the natural resources? Who is not considering the fact that coastal communities are reliant on the ocean? You look at the policy itself, which is your marine spatial planning bill. It doesn't speak to the needs and the sources of livelihood for coastal community. So this is a symptom of a government that doesn't care about the poor, a government that wants to silence the coastal communities. And because the only thing they are married to is giving a license to a multinational corporation that is already rich, that has made profit everywhere, at the expense of the rights, constitutional rights of people to a safe and healthy environment protected for sustainable development. When they have not investigated what an existing right now, how many billions of rands do people worth of the livelihood they derive from the ocean? No one has done that. But they want to go ahead and say an option to sell the ocean to oil and gas explorers is an economic development, is good for rural people when they haven't done their homework. So that statement undermines us. That statement tells us that they don't hear us, they don't see us, they don't want to hear us. That statement tells us we are going to court because our public servants, our politicians don't want to listen to us. The minister had an opportunity to come and listen to us, but instead chose to go and speak to traditional leaders, knowing quite well that traditional leaders have got no right to speak on behalf of communities unless they have been given a mandate by the people, because we live in a traditional system which is a bottom-up system. A traditional leader can only speak on behalf of his or her people once given a mandate. So we have a serious problem in this country of the politicians that when they are voted into power, they want to do as they wish. They no longer want to come and listen to us. They don't want to hear what are our aspirations about the future, about the development. They don't care about what the climate crisis is doing to the poor, to the rural people. So this statement is a very, very pregnant statement that would need a very serious lab to dissect and to find out all that it relates to. I thank you.
Thank you, Sinagugu. That was incredibly powerful and I think resonated with a lot of people. There has been a few requests to turn your answer into a TikTok, so we will work on that. There have been a few questions in the chat that overlap just related to the extent that this judgment could set a precedent and the impact on potential cases going forward. Jomo, I'm going to ask this to you and also to Melissa. Your community has been failed by the government over and over and over again, and I'm wondering if you believe that this groundbreaking judgment will change some of the attitude, or are you hopeful that this is the beginning of something new? You are on mute. Kindly unmute.
Priyanka?
Hi, Jomo. Are you hopeful that this judgment, which is a win for the communities, will help your community in the long fight that you've had with the government, getting them to listen to you?
Okay. No, the government obviously already failed us, because if the government consult us, even today we are not talking about the case at the High Court. That is why I'm saying, I'm trying to say the government, it's not consult us, even the Inkosi, once you give them the money, and then that guy said, okay, everything, what you only want to do it. No one can stop you. So on my side, government, if we change the rules of working in Bozobona, that thing affects us, because put that invite on the newspaper or Twitter, but almost of the people sitting there that have villages we don't have Twitters and daily dispatch newspapers. So all in all, government came to us. Let's share about everything, not about Ushel. So, okay, thanks for now.
Thank you, Jomo. Melissa, I'm going to ask you to please speak about the precedent issue, and particularly a question has just come up now, how this might also impact other courts in Africa and beyond.
Yeah, thanks for that question. Look, I think it's the clearest example we have of the link between need and desirability and climate change. Obviously with the Earth Life Africa judgment, that was all about also considering climate change impact assessments, climate change impacts through climate change impact assessment. But insofar as need and desirability is concerned, I think it's really important from bringing in the policy context, the international considerations that come into play when looking at needed desirability of these types of projects. And obviously the judge wasn't in a position to find that it is needed and desirable, or is not needed and undesirable, which we say it is. I think it's particularly pertinent to bring those issues together. It's an argument that many of us have been making for quite some time now. So for that acknowledgement to come out through this judgment, I think is really important. Whether a decision maker will actually come to that conclusion is a good question that you raise. But nevertheless, I think, a part of the development of this kind of jurisprudence is going to be incremental. Since we're also seeing right to food being brought into this climate change context and in terms of need and desirability. So, I think this is a really good step in the right direction in our jurisprudence, and it will really has good potential to be developed further in our law through judgments to come. Then the second question, Priyanka, did you want me to respond there as well?
Yes, you're welcome to.
Okay. So as this is a High Court judgment in the Eastern Cape, it's obviously it doesn't have the same precedent status as it would if it came out of the Constitutional Court. But nevertheless, we are, increasingly seeing how the different divisions in our high courts are relying on each other. So the Earth Life Africa, that was obviously a judgment of the Gauteng High Court, and that came out very strongly in this case and is continuing to come out. So from a South African perspective, I think this is a good precedent. There are a number of similar related cases that are in the pipeline that are to be heard before the court. So this will have a significant impact on those decisions, I believe. Then in terms of an African precedent perspective, I think there is some, I think good reliance can be made on this. Whether it will be applied by other courts, we would have to see. It also would depend from jurisdiction to jurisdiction. Thanks.
Thank you, Melissa. There is a question in the chat that says, do you have any advice for Namibian communities who have just lost an urgent court interdict against Canadian oil drillers, Recon Africa, and the Namibian government? No free, prior, and informed consent, land theft, and human rights violations happening in the Kavango regions. Nontle, do you have any advice, and can you answer this question?
Free, prior, informed consent is one of the national laws that mostly our communities that are not aware about it. In order for those laws to work, we need to run awarenesses or some advocacy in our communities. Because in order for that law to work, you need communities to organize themselves to make sure that these laws must be used. Because if we rely on legal advices only, that as communities, that our lawyers, if there's lawyers are going to fight in court, it's really a difficult battle for the lawyers to fight alone without communities. My advice is that they must take the right to say no. The right to say no is the way to go to free, prior, informed consent, where communities, they learn, they understand their rights, that they have a right to choose. They have a right to choose the development that they want, and they have a right also to decide. If those rights in communities, they are very aware, it's easy to those companies to not to take an advantage. But if communities are not aware about their rights as well, government together with the private sector, is very easy also to go and bulldoze the communities. But if communities, they are aware of their rights, it's not so easy. That is why I suggest that right to say no to communities is a very important campaign, that communities must understand that they have a right to say no. Thank you.
Thank you, Nontle. I am going to go to Jatine's question, which is that court orders are generally an ineffective means to ensure policy change. What is the way forward with using this judgment to ensure policy change through advocacy, outreach, and lobbying? Vilmin, can I give that question to you?
Sure. Thanks, Priyanka and Jatine, and I think others might also have something to say about this. So, firstly, I think the beauty of this case is that it didn't come out of the blue. It is part of this incredibly long struggle from communities like Kolobeni, like Dwesa-Cwebe. And this was just a natural progression of that. So, the gains made in the Baleni judgment, for example, or in the Gongogoshe judgment on Dwesa-Cwebe, those were the building blocks on which this judgment you know, just build forward. So it's part of this bigger picture, which I think, which to me certainly is one of the satisfying and beautiful parts of it. But that campaign that I'm talking about, I think acknowledges exactly what you are alluding to, Jatine, that you know, the courts play an important role, I think, in taking the discourse forward, giving us hope, and giving us something to mobilize around. But that mobilization and advocacy is actually where it's at, right? Where the important things are happening. And what's so beautiful to me is that just 2 weeks ago, land activists and communities from across the country came together to talk about their land rights. And the very thing that they kept saying was, you know, we demand to be taken seriously as individuals. We demand to, you know, for our voices to be heard, which is then exactly what this court case confirmed. And to me, it's really, you know, the court is kind of following this wave of resistance and advocacy from on the ground, which, you know, which I think is unbelievably powerful and is really was going to change things. I'm and Nontle and others are in far better position to talk about that solidarity, advocacy, movement, and this case, of course, brought something else, which is linkages to environmental movements, other movements, which I think has been very important to kind of grow this wave. The last thing I'll say about it is what also came out of the land conference, and which I think is pertinent here, is that community activists like Baby and others who are on this call were saying, we are no longer going to wait for the state. We've done so for 25 years. Our call is no longer for the state to do anything because we don't trust them to do anything progressive. Our call is to our brothers and sisters in the same position, to lawyers, to civil society, to join us in bringing an alternative and solutions from the bottom up. And I think that this court case has been important in driving that, kind of making connections. And that's where the change is going to come from, not from the court order, exactly as you've said.
Thank you, Vilmin. The next question is from Nicholas King. Melissa, if you could kindly take this. Was the issue of ecocide, which is gaining considerable traction globally as a crime against humanity, raised in the submissions? Has it been raised in any South African case yet?
Thanks, Nick. No, it wasn't raised in this case. Certainly the interests of the whole community, the whole coastal community, as I referred to earlier under the Coastal Management Act, it did come to the fore in the affidavits, but ecocide itself, no, it hasn't been. I am not aware myself of any cases currently before the courts that are introducing ecocide, but there are a number of other lawyers on the panel and in the audience who might have some insights on this. Thanks.
Thanks, Melissa. I'm going to invite any of the panelists who would like to share further reflections to please either turn your camera on and unmute yourself and do so. Otherwise, I will move to the final question and closing statements. Okay, Vilmin.
Sorry, Priyanka, I wasn't sure whether anyone had answered Baby's question or whether that is the last question you're referring to, but I just wanted to make sure. Can I just quickly read it?
Yes, sure.
So she asked, why is mining companies only targeting rural communities? Only land that belongs to African origin persons are targeted by mining companies, and our government doesn't protect us and even ignore the Constitution. Private land only applies to whites, as if our ancestors did not pay with their hard-earned money, life, sweat, blood, and tears. And I think it is a really important question, and I just wanted to share some thoughts on that. I think that's very true. That's what we see, developers absolutely targeting communal land. And I believe it is because in the 25 years since the Constitution, we still have not provided tenure security to people living on communal land. It still belongs to the state and is controlled by traditional leaders, and that makes it very easy for a company to convince one person to hand over vast swaths of land, and they don't have to do what they would have to do if they entered a community where people have title deeds or ownership over land individually. That's way too much trouble. It'll be too expensive. And so, communal land is absolutely ideal. And here we're talking about the ocean, which they must have thought is even better because there's no one there. And, for those two reasons, again, I think this judgment is really important for one, to show that this practice of convincing the chief is sufficient. And secondly, this notion that the ocean is kind of belongs to no one and there's no one there, and therefore it's terribly easy to enter that. So I really think it's, to me, it's deeply rooted in discrimination and in the continuing perspective on Black rural people as invisible, their rights being invisible. I mean, and that that decisions can be taken over their land and resources without their consent is just extraordinary. But it's what we see every day, and that, I think, is a big part of why they continue to be the targets.
Thank you, Vilman.
And Priyanka, I wanted to add that it doesn't only end there, but the parliament, the parliaments continue to pass laws like the TKLB, laws which are intended to make it easy for the government to take that land, to target that particular land. Okay, so I will, So that's what I wanted to add, that we're seeing a string of these laws that are targeting communal land areas, where government is trying to make it very easy for the communal land, for these rural areas under traditional leaders. That's why in the TKLB, the Traditional and Khoisan Leadership Bill, where they have even put in clauses there that say actually a traditional council could sign a deal with the investors without consulting people. So also, it is for that reason that such important and powerful legislation such as IPILRA, the Interim Protection of Land Rights Act, they still remain interim up until today. And there is no replacement law when the Constitution requires that a permanent law must be put into place to replace, to keep that which is in IPILRA. So, but they are not doing it. So IPILRA, which is the law that affirms the rights of people living on communal land, is not being taken care of by this government because it's convenient for them to take away the land of rural communities. Thank you.
Absolutely on point, Sunagugu. Thank you for that. There is a question from Gary in the chat related to the assessment of harm. What does this judgment mean on that going forward? Does it mean that seismic surveys must hold off until this can be established? Melissa, could you kindly answer this question?
Thanks for that question, Gary. So this judgment does not have the effect of a moratorium on seismic surveys or other exploration activities. In relation to harm, I think it's particularly important because of the now much wider understanding amongst the general population and hopefully also the decision makers around what the impacts actually are. I think it brings a new dimension to the consideration of harm, particularly when there are competing expert views, in that the judgment says that a precautionary approach must be applied in those circumstances by the decision maker. So if the decision maker were to make the decisions properly, taking into account all of these different, all of these possibly competing reports, then that decision maker should be favoring a precautionary approach and is such that the activity shouldn't be authorized. Whether that will happen, we will have to see, but we do have this great judgment which we can rely on. But for the moment, no, there is no moratorium. However, I do think it will have an impact on the nature of the impact assessments that will have to be done for any of these applications.
Thank you, Melissa. I am going to ask Nontle and Sinagugu and Jomo and the other participants to share their final reflections. So Nontle and Sinagugu, can we please start with you? Any reflections on the judgment you would like to say or closing statements?
Yeah. According to this judgment of yesterday, what I want to say is that as from now, we need to be go-getters. We need to work hard. There's still a long way. We need to mobilize. We need to lobby. Our communities, we need to run an advocacy. It's a lot of work that is ahead of us. This judgment, it doesn't tell us that we must go and stay at home. It tells us that there's a lot of work that we need to go.
I would just like to add that to what Mancha says, that we may have a beautiful co-constitution, which is regarded as being one of the most powerful globally. But if we don't take our beautiful legislation and constitution to court to establish these precedents, it will remain just a piece of paper. So the only way that we can breathe life onto the legislation is to have the willing legal teams to be able to go out there, to be brave enough. And by so saying, I would like to pass my gratitude to the entire legal team that has been able to go out there and to fight on our behalf to set this amazing precedent. We know that the war is not over, but it requires not just only these coastal communities, it requires all of us if we are to make sure that the life on this planet continues to allow us as a human species to exist. We need to do more and more of these things to bring life to our legislation, to our constitution, and to fight for the planet so that we can have future generations. Otherwise, we are the ones who will die and go to hell for having kept quiet and did nothing when the planet was faced with the extinction because of the decisions that were being taken by authorities. And we had an option of going to court to stop it. Thank you.
Thank you, Nontle and Sinagugu. Jomo, do you have any final thoughts or reflections that you'd like to share? Jomo, can you hear me? You are on mute there we go.
Okay.
Would you like to share any final reflections or thoughts? Thanks.
Yeah. Okay. Also, as from here yesterday, I'm very, very excited. I'm happy and I don't have a lot of words because that judgment show us we need to work harder than first time, because that judgment is not covered about Shell and ministers. So obvious that team, maybe today, you maybe prepared the plan, what we fight with that judgment. So even in my community, when I'm tell that judgment, I know everyone is happy about that judgment. So we need to fight anything as over from Shell. Also, thanks very much, Priyanka and Volman, working harder, but now we are happy. Thanks.
Thank you, Jomo. I am going to ask Volman, before she shares her final reflections, to just answer one question from the chat, which is, does the judgment have ramifications for potential offshore exploration, such as searcher geodata seismic surveys off the West Coast? Thanks, Volman. Over to you.
Yes, thank you. So we are very familiar with Searcher because the West Coast fisher communities, of course, took them, successfully got an interdict to stop their exploration in January this year. So we understand that they have brought a new application, but it's much further offshore. So yeah, I think in a clear attempt, I would say probably in an attempt to avoid any human interaction, any potential fishers. And so what this judgment does is go way beyond those complaints against Searcher, which I think is going to have big ramifications. So what the judgment says is that there are certain things that the decision maker must take into account, including climate change, including ICMA, etc. And those arguments were also made against Searcher the first time around, not exactly like that, but certainly this argument about the cumulative impact that needs to be considered. This idea that you can't look at an application for a seismic survey in isolation. And I really think that this judgment supports that argument very strongly. So I think in future it will be much easier to challenge a decision if it is clear that the kind of bigger picture, which includes climate change, which includes an integrated approach to the ocean and so on. If there's no evidence that was considered, then I think that will get someone like Searcher in trouble, even if they are very far offshore, because of course the ocean doesn't have the kinds of boundaries that they would like to think it does. So I think it will have ramifications for all future applications and decisions to award these permits. And as a final reflection, just to say what an enormous privilege it is to work with people like Jomo and Senegugu and Nontle and others who, we now and then we get a glimpse into what it is that Jomo, for example, and others go through and struggle with on the ground in Dwesa. We haven't even touched on it here. And yet there is just this unbroken spirit for a struggle, and it's just such an honor to be able to try and put that before a court, and very rewarding that courts are finally starting to listen to things that previously would have been irrelevant. Thanks, Priyanka.
Thank you, Wilmin. I'm going to invite Melissa to share her final reflections before closing off.
Thanks, Wilmin. I just would like to echo Wilmin's words, and that this is really a struggle about it's a win. It's a win for the communities that are facing these struggles every single day. It's a win for not only the applicants and the applicant communities that are named in this case, but it's a win for all those communities along the coast. It's a win for the communities who might be facing similar struggles currently or in years to come, in the interior of the country, as we are facing oil and gas threats in relation to fracking and other activities. So this is certainly a great step forward, and it's a wonderful judgment for all of these communities. And what has been wonderful about this whole case is that it has not just been about what has happened in court, but what has happened outside. And we've seen people from all across the country, from in every station, coming together and raising up and raising their hands against Shell. Thank you.
Thank you, Melissa. And I agree and echo both what you and Wilmin have said. It has been an enormous privilege working with Jomo and Senegugu and Nontle, and their resilience is unparalleled, and we can all learn a lot from them. In closing, I would actually just like to ask Wilmin one final question. Is this the end of the road? This has been a huge victory for the communities, but do you think Shell will appeal, and what do you think the next steps would be?
I do think they will appeal. I think the minister may well also appeal. I don't think their prospects will be great. But even so, I do think they will appeal, and I think whoever might lose at the Supreme Court of Appeal will appeal to the Concord. So we may well, just get higher and higher decisions on this issue, which we won't complain about. It is, of course, possible for Shell to now apply for leave to appeal and then say, well, that suspends the order, and then try and implement the permit this December. I doubt that they will do that, because our communities, I'm sure, will instruct us to go back to court and interdict them. So I don't think that will happen. It's more likely that this fight will continue in the courts for the next 18 months, I would think. But of course, based on everything that we've said, the struggle is a much, much bigger one. We know that there are currently about 30 applications for seismic surveys all around the coastline, and we're not going to stop those one by one in the courts. We have now at least made sure that the decisions around those permits must be better decisions, must be actual decisions, and not rubber stamping. But that's a small victory in the far bigger scheme, which includes public pressure and public discourse and power from below, and that, to encourage everyone here to throw their weight behind these very local struggles, because they're very powerful, and I think that's where it's at for the foreseeable future. Thanks.
Thank you, Wilmin. And since Johan is not here, his go-to line is that we owe these communities endless solidarity, and I think nothing is truer. I think we have come to a close for this webinar. I'd like to thank all our panelists and definitely all the guests who have joined us, and thank you for your questions, and we hope that you found it really engaging and fruitful, and our endless support and thanks to the Wild Coast communities, to whom this victory really belongs. It's been incredible. It's been a long fight, sometimes a difficult fight, but we are endlessly grateful for them for continuing to fight for both the people and the planet. So thank you all.
Thank you, Priyanka.